ACSblog is here with Peter Shane, a law professor at The Ohio State University Moritz College of Law. Professor Shane, what do you think of President Obama's determination that the intervention in Libya is authorized by the War Powers Resolution?
The original decision to intervene in Libya was based on an interpretation of the War Powers Resolution that is pretty conventional. That is, presidents have routinely looked at the War Powers Resolution as confirming Congress's willingness to go along with a limited executive branch power to initiate military action for limited purposes based upon weighty national security interests. So when the administration released its April 1st legal opinion on the initiation of the operation in Libya, it was resting on claims of executive power that both Republican and Democratic administrations have made for quite some time. The greater controversy has really been not so much over the initiation of the Libya operation as its duration. So under the War Powers Resolution, not only is the president required to make a report to Congress within 48 hours of initiating certain kinds of military deployment, but if he puts U.S. armed forces into what the statute refers to as hostilities, or a situation where the risk of hostilities is imminent, then the War Powers Resolution says to the president, okay, you have to get those troops out of there in 60 days unless we give you specific authority to keep them there longer, or unless you need up to 30 additional days to withdraw them, but that has to be expressly certified. So those 60 days ran on May 20th. The administration at that point had not said anything about asking for an additional 30 days. It didn't say anything about what it was doing with regard to the War Powers Resolution at that point. Just this week, however, the White House released a report that indicated that they thought the 60-day provision of the War Powers Resolution did not apply to the Libya operation because as the word hostilities is used in the relevant section, they thought that the nature of the armed deployment in which we're currently engaged didn't reach the level of hostilities. On that, we don't really know very much about their reasoning. They explained several factors that they thought were limiting factors. And I guess my opinion based on just the one paragraph view on that question is that the administration has made an argument that you could probably make with a straight face. I don't think it's necessarily the stronger argument. I mean, at this point, they're arguing that even that because we don't have boots on the ground and we're not flying any or hardly any sorties ourselves against Libyan targets, that this doesn't amount to hostilities, but it's still the protracted use of lethal force in which we're implicated. It's sustained, it's continuous, and it's against a country that had not attacked us previously. So it's an offensive, it is an aggressive use of military force. I think it's an uphill climb to argue that that does not amount to hostilities under the statute. Again, a lawyer can make that argument and not be ashamed, but it's not necessarily the best argument.
I know you have a theory about sort of how President Obama is interpreting this and what his view of the War Powers Act is in this sort of context. Can you talk a little bit about that?
Well, I guess what I have is speculation.
Speculation, yes.
And my speculation is that our State Department, under the leadership of Secretary Clinton and the legal advice of Harold Koh, is a State Department that's very deeply committed to an aggressive policy in pursuit of human rights. And I think, and my speculation is, that they would like to create or preserve, however you want to put it, presidential authority to deploy military force for humanitarian purposes to protect civilians, at least where that can be done consistent with international law, and at least when that can be done without putting U.S. troops in harm's way for an extended period of time. And if that's what they would like to see created, I think that's a good debate to have. I think people obviously have memories of our inaction during Rwanda and then what we did try to accomplish in Bosnia and Kosovo. And this may be another good example of that. If that's something that the United States should be prepared to do, and if the president should have legally recognized authority to engage with this sort of problem for more than 60 days at a time, then the administration should propose legislation that would enable presidents to do this. It shouldn't, I think trying to create the precedent by an easily challenged interpretation of the War Powers Resolution is just not the most helpful way to preserve checks and balances and show that what you're doing is consistent with the rule of law, which is what it should be.